Welcome to All Things Real Estate. My name is Margaret Capranos. I'm a real estate agent with Zephyr Real Estate. We're here today to meet our tax assessor, Richard Benson, and we're going to be talking about real estate taxes. So welcome, Richard.
Thank you. It's great to be here today.
Oh, great.
Yeah.
You are both tax assessor as well as recorder and also
County clerk. Technically, I'm the assessor and not tax assessor, but assessor,
Okay.
recorder, and county clerk. And we do everything from deeds to marriages.
Oh, marriages too.
Absolutely.
I didn't realize that. Okay. Well, see, we're here to learn today about what the assessor does. Tell us a little bit about this, because this is an elected position that you've had now. You're in your second term.
Right. Yep. Second term as an elected, second year of my second term. Been in the office for about 30 years, which seems like a long time, but it goes very fast. And again, we cover both the assessor's office, which does the assessments of property, real property, business and personal property that's locally assessed. And then we do all the recorder's office and the county clerk, which is a variety of licensing and marriages and so forth.
Okay. And you've been with the county since 1985.
That's what they say.
That's what they say. You started out as
an appraiser
As an
one.
appraiser one,
Yeah, and
okay.
then worked my way through the appraisal series and different positions in the office, standards, assistant assessor, and then was elected 6 years ago.
And how many people do you manage in the office?
We have about 80 people in the
Oh,
office.
it's quite a large department.
It's a pretty good sized staff, yeah.
And recently, you presented the tax roll numbers to the Board of Supervisors, presumably.
Yeah, we close the assessment rolls annually every year by the 1st of July, and it's the process that we work on all year as a long-term event. The recorder's office and the clerks kind of work day to day, but the assessor works all year, kind of working ahead to finishing what's going to be the tax bill next year. So we work basically on activities from January 1 through December 31st, and then those activities become the basis for the tax bills that arrive in the following fall. This year, somewhere around September 30.
Now, this money is mostly the county budget, presumably, from property taxes, correct?
The property tax revenue is distributed to cities, counties, but most of it goes to county schools, to the school districts. Only about 17 to 20% goes to the county. Most of the property tax revenue that is received by cities and counties is the largest piece of their discretionary revenue. And in terms of size, for us, it's a very big number. We lead the county in some of the biggest statistics per population. Our role is over $70 billion, which is a very big number.
That is a very big number.
And so on a per person basis or per capita in the county, it leads the state behind, I think, San Francisco and San Mateo County.
Great. So we are a very wealthy county.
Well, it's a pretty expensive county to
Yes,
live in,
yes.
and the real estate pretty much reflects that.
Correct. I see that all the time. So what we're here today, I find from a lot of the clients that I have, they ask questions about exemptions, and most specifically Prop 60, Prop 90. So I'm hoping that we could shed some light on what Prop 60 is, what Prop 90 is, and how it works.
Sure. So we talk in our world about exemptions and exclusions. And exemptions are usually something like you don't have to pay a tax. When we talk about property taxes, there's a couple different classifications of taxes: property that's taxable, property that's non-taxable, property that's subject to exemption, and property that's subject to exclusion. So non-taxable property would be like government-owned property. Taxable property, locally taxable property, would be real estate, business, and personal property that's locally assessed. Some property is assessed in the county, but it's assessed by the State Board of Equalization at the state level. Example, railroads, utilities, property of that nature. Within the taxable property or property that's subject to exemption or exclusion, exempt means, for example, a property that could be a church or a school or something of that nature that's exempt from property taxes locally, but it's not a non-taxable property like government property. Then property that's subject to exclusion would be property that most citizens either own or rent or something else that's subject to an exemption, providing you meet the qualifying criteria for that exclusion. So Prop 60, Prop 90 is an exclusion. It was passed and went into effect, I think, in 1987, allows somebody over the age of 55 to transfer their base year, technical term under Proposition 13, their tax basis, property tax basis, from one property to another based on certain conditions. Essentially, it means you're transferring a property of a higher value to a property of a lower value, and that allows somebody over 55 to apply for that and then carry their base year from one property to the next.
How often can they do that?
One time.
One time.
Now, there are some provisions that I think are changed or changed last year that allow both spouses to take advantage of that opportunity. And the reason that came about was because same-sex partners could do it because they weren't married. So married couples fell into the kind of community property law and weren't able. That change in the law, I think, is going into effect last year or this year so that both partners or spouses could take advantage of it.
So this is the domestic partnership situation that we're talking about?
Yes.
Okay. What happens during a divorce?
So ordinarily during a divorce, what has been is that one partner or the other had to claim it in prior years. Now I think both will be able to take advantage of it.
Both can do that.
Yes.
Okay. So explain to me and the viewers, Prop 60 is really the only proposition truly in effect here in Marin County in terms of transfer. Although Prop 90 is existing throughout the state of California, and this is only for the state of California because this is Proposition 13 that has triggered both Prop 60 and 90, correct?
Kind of.
Okay.
So Prop 13 went into effect in '78 and was retroactive to 1975. Prop 60 and Prop 90 didn't exist until the mid to late '80s. Prop 60 allows people within the same county to transfer that base year to another property within the county. And that's statewide. Prop 90, if it's approved by a board of supervisors, allows persons from another county to transfer their base year into that county. And in California, there's about somewhere between 6 or 8 different counties that allow transfers from a different county into their county. Marin does not. Now, in the early stages of the implementation of 60 and 90 for Marin County, Marin did allow Proposition 90 base year transfers into Marin. And the impact of that was fairly substantial in terms of tax revenue. What we found was a lot of persons from outside the county were moving to Marin and transferring low base years into Marin, and that tax base in Marin actually was not going up as much because that revenue piece wasn't changing ownership. Now the impact of that, even if it was to be reestablished today by the Board of Supervisors, would fundamentally probably have a long-term impact of compounding that effect and also shifting that tax burden, property tax burden, from people who are in the county. All of a sudden now you have people outside the county transferring base years. The tax revenue has to come from somewhere, or the
Right.
revenue has to come from somewhere. So what we may see if that was to be implemented again is if there's a need for taxes that's not being satisfied from these otherwise accessible changes in ownership, then what you sometimes see is special assessments or bond issues increasingly going on tax bills, predicated on people who don't live in the county getting a tax benefit.
Right.
So the burden would be on the residents of the county carrying the burden from somebody outside the county who's getting the benefit.
Interesting. So
And
for
it's-
those
And
counties,
it's a substantial number.
I would assume for Marin County, yes.
Right.
So for somebody, let's say, moving to a reciprocating, is that what you would call it, a reciprocating county that would allow that transfer, how would somebody find out about that? Do they need to?
That's posted on the Board of Equalization website.
Okay.
Again, I think there's somewhere between 6 and 8 counties that do that. You can also obtain the information from our office with a telephone call. We're happy to provide that information. And quite a lot of this information is available on our website.
Okay.
Just Assessor Marin County will get you there if you Google it. And there's quite a repository of information there.
I made that discovery. So any question you may have is, drop-down menu. You just click that little plus sign and you get a wealth of information.
And there's a lot of links there too.
Now, tell me a little bit more about how somebody going about selling their house would coordinate an inter or intra-county transfer.
So let's just focus on the terms a little bit, how it works. And that's irregardless whether it's from another county or within the county.
Okay.
So the way the rules are structured, somebody has to sell an original property and purchase a replacement. And in general, that replacement has to be equal or lesser value than the value of the property, the original that they sell. And they must do those transactions within 2 years of each other. So they can do it in either order, purchasing the replacement first, and then within 2 years selling the original, or selling the original first, and then purchasing the replacement within 2 years of the sale of the original. But those two events have to be within 2 years of each other.
And you have to be over the age of 55 for either event.
One or the other claimant has to
Okay.
be over 55, or the claimant has to be. If it's a couple, one or the other claimant has to be.
Okay.
Or if it's an individual, you have to be over 55 at the date of the purchase of the replacement. I think that's correct.
Okay. Now, there's a stepped-up basis as well?
Yes, depending on the order of events, if you sell the original first and buy the replacement second, then if you buy the replacement within 1 year of the sale of the original, the replacement could be as much as 5% higher than the value of the original sale. Within the second year, it could be as much as 10% higher.
Now, this is for a primary residence. This is not for a vacation property. So
That's correct.
You are transferring from a primary residence to another primary residence.
That's correct. Principal place of residence.
Principal. Okay. So with that, then, you can have somebody have a single-family house and then go ahead and purchase a townhouse or a condo or another single-family house, and they would
Yes.
be fine.
Yes.
Now, the trick here in Marin County is if you purchased quite some time ago, the value of your house at that time is considerably less than what you could purchase today. So how many people are able to take advantage of that, and what are some of the strategies to deal with this very real problem?
So we have about 100 of those a year in Marin. And the first strategy is to learn the rules, which means looking at the FAQs on our website and or the Board of Equalization, talking to professionals to make sure you understand what the rules are and the regulations, so you don't get trapped because you didn't reach a certain age at a critical moment, you exceeded the purchase price, or you exceeded the value test by a nominal amount, or you're trying to figure out, is there a way for me to make this work for me that otherwise wouldn't work that might be apparent, like maybe doing a remodel or doing new construction after the acquisition of the replacement, something that may allow you to achieve what your goals are and not get you trapped. So reading through the statutory scheme of the rules is really important to do that. Other things could be whether there's a second residence on the property or not. Little things that you need to make sure are not going to interfere with that processing going smoothly. You have to fill out an application. The application has to be filled out within 3 years of the date of the sale of the original in order to receive the benefit as of the transaction date. But if you complete an application later than 3 years after the sale, then it can still apply, but prospectively. So it would be from that date onward rather than going back to the transaction date.
That's quite a bit of processing information.
It's
So
a
you're
lot
re-
of
yes,
processing
yes,
information. This
yes.
particular section in the tax code is one of the lengthiest sections of rules that exist. So it's really important to kind of go through it and make sure you understand the details.
Okay, that's great. So your strategy then would be, if you were to do this, you're selling your home today, don't necessarily look for a turnkey property, but look for something that may need to be remodeled.
Turnkey property could be fine. It just
If you
depends
could
what
find
you're-
something, it's
Yeah,
equal
that
or
fits.
lesser value?
Equal or lesser.
Okay,
Yeah,
so that may
sure.
be a little tough to do today if you purchased quite some
Sometimes.
time ago.
Yes, but
So-
it doesn't matter how long ago you purchased it. It only matters what the value of your property is today.
Okay,
So sometimes people actually look at it in the reverse angle, which means doing some improvements to their original before they sell it,
That's
so
a
that
good
they can
idea.
raise that value up to get the property that they want. So there's some different opportunities to try to figure out how to make it work.
that's very interesting. I hadn't thought of that.
Right. Because if you can raise the value of your original, then you're effectively raising the value of the property that you're able to purchase and still meet the criteria
Right,
of the
right.
equal or lesser test.
Okay, well, that's very good to know. So in terms of what would happen if you were to go ahead with that house that you would then fix up, and it's being remodeled and it now has an enhanced value, you no doubt are coming back to reappraise or reassess.
Conceivably, it depends
Okay.
on your timing. So a property that is, let's say, maintained in good condition and has been kept up, any repairs or maintenance to that property is non-assessable. If you do an addition or do a renovation, it may be assessable. So if you renovated a property before you sold it, that renovation may be assessable as an assessable activity, raising its base year. But that still may be less, or still may reap the benefit of transferring a base year to another property. You kind of have to go through the exercise. And I was going to say one of the things that's important in those preliminary steps is to look at the application and look at the rules and read through them before you embark on any of these things to try to see is it feasible, and talk with advisors, professionals in the field, and or the assessor's office to see how it may play out.
Now, how do you go about reassessing property? Because we have Prop 13 that limits how much you can go ahead and
So-
raise.
13 limits the assessment from one year to the next, but when we talk about Prop 60s, we're really dealing most of the time with sales prices. The sales price that the original sells for and the sales price that the person pays for the replacement. So that sets the mark for the comparison between the two properties.
Okay. Now, you had also mentioned, switching gears a little bit, that there is another exemption that you see more frequently in this county, and that's the transfer from parent to child. Would you like to talk about that a
Yeah,
little bit?
that one actually we see more of. We see about 100 of the base year transfers a year, but we see about 600 of the parent-child transfers a year, and that is also an exclusion from reassessment for qualifying transfers. Again, you have to make an application. The transfer has to happen before the house is either sold to a third party. The application process is 3 years, again, but allows parents to transfer that base year to children, and so the children can enjoy the benefit of that base year for whatever period of time. There's also a provision that allows grandparents to transfer to grandchildren, and that's a like provision, except that if grandparents transfer directly to grandchildren, then the natural parents have to be deceased for that exclusion to apply. However, if the grandparents want to transfer to the grandchildren and the parents still are alive, natural parents, then they could transfer from the grandparents to the parents and the parents to the children, even through that series of steps, and it would still be subject to the exclusion provisions. Again, you have to apply. Again, it's being careful to read what those rules and regulations are, and probably making sure that you understand those steps before you embark down the road of doing the transactions.
And again, this is on the principal residence. So
This can actually be for any property.
for any property.
The
okay.
limitations become subject to either value conditions, or in the case of a principal residence, there's no value limitation. There is a value cap on other than the principal residence, but what we see is many times people are able to still take advantage of that and transfer property either up to that value cap, or the value cap, using maybe both parents, can double it up, and it's not based on the market value at the time of the transaction, it's based on the assessed value. So again, the devil is in the details, looking to see, well, what's the assessed value at the time of the transfer? If it's less than the value cap, then it can qualify.
This is very complex.
It is complex.
So now how would that play in if a child ends up inheriting from a parent or a grandparent? How can they then, or perhaps they can't, utilize Prop 60 or Prop 90 if there was no value exchange at the time?
Well, Prop 60 or Prop 90, remember, are not parent-child transfers. They're transfers from one base year to another.
But an adult who's inherited property
Right.
now wants to...
Let's say, for example, that a parent transferred property to a child, what we call Prop 58, and the child now has the property under what was the parent's old base year value,
Right.
and now they want to transfer that base year to a replacement, otherwise qualifying, predicated on age and everything else, they're able to still do that.
They can then take advantage of Prop 6090.
Yes,
They can.
yes, because they basically have that property, it's their base year.
Okay.
It's the child's base year, and now all of the things meeting the test of equal or lesser, should they transfer it to a replacement, they could do that.
Would you recommend that somebody who is contemplating doing this, yes, they would come in to see you as well, but presumably like an accountant or a tax advisor should be well versed on this topic as well?
Yeah, you know, I've been in the office for 30 years, and I still consider myself a student of property taxes. And you're right, there are a lot of nuances. So most of the transactions are fairly normal that we see. It's only from time to time that they're more complicated. But unless you explore that to make sure that your transaction is fitting without the complications, you may not know. So talking to an attorney, a tax advisor, somebody in our office, educating yourself on the websites, which actually is not that complicated to do, looking at either local assessors, the Marin County Assessor, or the Board of Equalization. There's a lot of information that's relatively easy to read to understand the rules.
Now, for a property held in trust, are there any nuances that you need to know about?
Trusts generally aren't any more complicated than non-trust property, because what the assessor does is look basically through the lens of the trust to see who are the beneficiaries. And we're still looking there to say who owns the property through the lens of the trust. Now, where it does change is when we're dealing with a property that's in an entity, like an LLC or a corporation or something of that nature. The rules are different. And sometimes people may own a property, let's say a property that's used in the course of a business that's in an LLC. The parents own the LLC, they transfer it to children, but now it's transferring from an entity to children. And that doesn't work, even though the parents wholly own the entity. So if you made the step of transferring it out of the LLC to the parents and the parents to the children, you may be able to do that. But that is sometimes a trap, because people think, well, I totally own the LLC as parents, so why can't I just transfer it to the kids? That one you have to be careful of.
Okay, that's good to know. Well, another topic is on supplemental property bills. We have buyers who are buying at a new base and getting a tax bill based off of the prior owner's tax base. So then they get either one or two supplemental bills depending on when they purchase.
Yeah, depending on the time of year. So
Okay.
when Proposition 13 was implemented in '78, it didn't originally contain a provision for what you might otherwise call catch-up. In other words, somebody could buy a property in between lien dates and not get reassessed until the following, maybe perhaps as long as 18 months later to the following lien date. 1983, there was legislation to implement supplemental assessments, meaning mid-year through the year, if there's a change in ownership or assessable new construction, the property gets reassessed at that point. So in addition to the regular tax bill that comes out during the course of the year, like the ones that we will see at the end of September with 2 installments, supplemental bills are generated when there's a mid-year transaction. And it will either generate, depending on when the event happens, if the event happens between January 1 and June 30, then there'll be 2 supplementals because it affects 2 fiscal years or 2 assessment years. If it happens between July 1 and December 1, there'll only be 1 supplemental bill. If there are multiple events, then you'll get multiple supplemental bills that could be, more than that. But in general, 1 supplemental in what we call non-window period, and 2 when it happens from January 1 to June 30. And that's the difference between, in most cases, the purchase price,
Okay.
the new value, and what was previously on the roll, the prior roll value. And that's that difference. Now, what happens when people go into a sales transaction is that regular bill is prorated. Whatever the existing regular bill is prorated in escrow, but the supplemental bills then are generated after that.
Okay, that's good to know. Now, if somebody has a dispute, what then? What would they do?
Great question.
Okay.
So there's 2 ways to try to ask questions kind of formally and informally with the assessor about values. And we saw this a lot after we had the economic decline in 2008, 2009, when property values really went down. And so people who may be in that scenario for one reason or another, or now as we come out of that scenario and values are increasing, sometimes people say, well, I'm assessed too high. And so they can simply ask with an informal review at the assessor's office, and there's a form on our website to do that, to have us review that, and we will review that assessment. And there's a filing period for that, which is from July 1 until October 30 or 31st, I think. And that's an informal process. And if that doesn't resolve it, or if it doesn't look like it's going to be resolved, there's a more formal process called an assessment appeal. And that filing period in Marin is from July 2nd until November 30th. Those issues are heard with an independent body, the Marin County, one of 2 Marin County Assessment Appeals Board, who basically hear the case, kind of an informal trial, so to speak, where the applicant presents their information and the assessor presents their information. They listen to both parties and then render a decision on what they think the assessment could be. And that could involve either a change in ownership decision or a value decision.
Great. Well, this is a lot of information. We're nearing our time. So I really want to thank you for coming and providing us with this great information. Thank you so much for watching, and I look forward to doing other programs on real estate. So this is Margaret Capranos, All Things Real Estate.